start and Chelsea to send her Zoom information. All right. Well, this seems good enough. Welcome everyone. So this week we are having another Q&A. Remember, it is general information. It is not legal advice. So even if you submitted the question, that does not mean that more information wouldn't be warranted from your own association counsel. Feel free to keep your videos off. You can put them on. I can't really see you anyway because of how my thing is, so dealer's choice. Please keep yourself on mute unless you're asking a question. And remember that the chat function is intended for questions or requests for clarification and commentary. In the chat is not legal advice. And we will have time for additional questions today, so start thinking now of what you have. We'll probably get some follow-ups based on the questions submitted as we go through them. And then I'll say a reminder at the last question so you can have more time. And if we don't get enough questions, you will get some part of your day back. So with that, I think we have a little primer that Lisa's going to talk about, and then we'll get into the questions submitted in advance.
Good morning, everyone. We kind of figured that almost 8 months into the year, we could kind of check in about the new collections provisions that are in everyone's statute that started this year, January 1st, 2026. Because we are seeing in my collections practice that folks aren't necessarily complying with the statute, and that means that you can't collect everything that you are owed as an association. So we just wanted to check in and make sure that we kind of clearly lay out, and I'm just going to do it very briefly, but just to remind you that we cannot collect and you cannot charge late fees, interest, administrative fees, and you can't take any collection action, period, until 15 days after you comply with what the provisions in the statute say. Basically, what that requirement is that if you have day 1 is the day the assessment is due, and day 15, the assessment is still not paid, we recommend that at day 15, you send a compliant notice. That includes the language that's in the statute called this notice of delinquency. And the terminology gets confusing because that is what they call that. And then there's also your notice of delinquency, which is a letter or information on what the person owes. So included in that compliant notice is the statutory notice of delinquency and a letter from you that explains, what is owed. And that will include a ledger and, a letter basically giving the person time to cure, giving them a reasonable amount of time, 15 days to pay the amount due. Critically, that needs to be sent by first-class mail to the unit and then to any other address that the owner has given you. So if you know that this is a rental unit, you probably have or hopefully have another address for the owner. And then it also needs to be emailed. So if you have an email address for this owner, you need to send it there too. Okay, so it needs to be sent 3 ways if you have all that information. Always to the unit, always to the owner's mailing address if that's different, and to the email address if you have one. If you don't have a mailing address or an email address, sending it to the unit is sufficient. But we cannot charge anything, and you cannot charge anything until that has been done. Once that's been done, so let's say you
Lisa, I think somehow you got muted.
Well, that's strange. Am I back to what part did I miss? Just what the charging was? Oh, now you're muted. I think our system is having an issue.
So I think last we heard was you send it out via email. If they don't have email, you still mail it.
Okay.
You can't charge anything until you send the stuff out.
Okay, we're gonna have to grab each other when we see that mute happening. Strange. Anyway, so once you send that out, you can then, after 15 days, charge 1 administrative fee if you have a professional management company of no more than $10, plus the actual costs of postage or mailing and printing. And then you can charge the $50 late fee or 5% of the unpaid assessment, whatever is the lesser amount. So we're seeing a lot of things where the association is just sending the statutory notice of delinquency to one of those addresses. So that wouldn't be compliant. We're sending just a notice to the owner saying this is what you owe. That wouldn't be compliant. You have to send the statutory notice with a ledger and amounts owed to all of the addresses you have, including the email address. Or when you come to someone like me and say this person hasn't paid, I say, hey, before I do anything, you've got to send all those letters. So I would just make sure that you're sending. The thing I'm seeing most is that it's not being sent to all the addresses. So just make sure that you're doing that. I don't know if I have
Um,
anything else to add. Kate, did I miss something?
I don't think you missed anything, but I have two things to add. I had
Great.
someone the other day say that, well, we get a lot of people being like, well, we want to be nice. We don't want to
Oh,
be
yes.
so threatening right away. And that's very kind, but the statute does not care. So you can send a kinder, welcoming cover letter with the statutory requirement that says, like, hey, we have to send this. Sorry, we know it's going to be aggressive. Um, and that's kind of one way to work around it. I also had someone say that they sent like a polite reminder to everyone saying some people are delinquent, which is also fine, but does not comply with the statute. So, if you want to send a reminder to your community because you have a lot of delinquencies, that's great. You just also still have to send these statutory notices of delinquencies to be compliant if you want to collect.
I've also seen folks sending out in their newsletter or their annual with their budget information, just, hey, just a reminder, the statute changed. If you get a kind of a seemingly aggressive letter from us, that's what the statute requires us to send. You can certainly do that. But if all you're doing is sending a nice letter first and not including any of that other stuff, we can't charge, and you can't charge the late fees, the administrative fees, interest, and all of those things until the statutorily required letters and notices are sent. So we agree it does seem a little bit aggressive because it right away starts talking about foreclosure and that can be scary. And a lot of folks don't realize that's a remedy. So if you want to put something in the cover letter, like Katie said, that says, attached is a statutory notice. We understand it seems aggressive or unkind, but we wanted to make sure we complied. And if you want to talk to your attorney about that, crafting something that is would also be appropriate.
When I'll,
Go ahead.
it also does, I mean, we say that sending collections files to your attorney early on helps speed up the process and ensure that there's a higher chance that you'll get all the money back. That doesn't mean that you have to send it to your attorney, but like if you contact Lisa or Tima or whoever your collections attorney is earlier on, that notice can go out and then maybe the board could work with the owner on their own payment plan or something like that. But at least you are protecting the association by making sure that at least all the options for collection are open.
Right. And if it comes to me now and you haven't done it, you've missed 7 months of late charges and interest if it started in January. So, think about that. Make sure that you're not losing the opportunity to collect or at least have something to negotiate with your owner if you're waiting too long. Don't know if there were any questions in the chat. I don't think so. So I will just go on to the next or our first pre-submitted question. The question is, our declaration clearly allows for the board to terminate utility service with proper notice for a unit, in this case, that has a 4-year history of delinquent payments. If we terminate their water, is there substantial case law to support such a move by a community association in Washington? So I want to, because this is kind of a charged topic, I'm going to say this again. This is just general information. We're not giving legal advice here. We don't know what your documents say, and I'll just full stop. We don't know what they say, so we can't interpret them. But generally speaking, if your governing documents allow for utility termination for unpaid assessments, then that's a remedy available to you if you have an old act condominium or a homeowner association 6438 community prior that was founded prior to 2018. However, you're going to want to definitely look at your local laws, your municipal laws, and make sure there aren't any other restrictions that may be there that are, occupant-friendly restrictions that may prohibit or restrict the ability to do that. You also want to realize that legislatures don't love this, and you don't want to be sort of in the court of public opinion either. If you don't want to be on King 5 News, having been the association that cut someone's water off. So you also want to think about who your occupant is and what time of year it is. If this person has known health concerns or young children or is elderly, those things might go into play. If it is January or really hot in August and you're thinking about power or electric cutoffs, that's something to consider. And you need to look at reasonability, right? Like everything else. So just think about whether this is a reasonable decision, aside from the fact of whether you have the ability legally to do it. There certainly is, to answer your question, case law that supports the right to terminate utilities if it's in your documents. It is allowed. But I will say there is a big caveat, and that is that nobody's going to be able to do this when Kiowa for All takes place in January 2028. So, and that's kind of, it looks at when I said that the legislature disfavors this type of thing, there's your indicator, right? They've basically said nobody's going to be able to do this come 2028. So just kind of keep that in the back of your head. If you're a Kiowa community, you can't do it now. What we would recommend in this situation is that you consult with your association attorney before you terminate utilities to make sure that you've kind of logically thought through all of these things, and then to make sure also that you do have that authority in your documents. But yes, you can do it if you have the ability to do it, but I think you definitely want to look at sort of the totality of the circumstances and why. I think the why is a big question too that you want to look at. Anything you want to add, Katie?
The only thing I'll add, because Valerie's not here, is, and I think it's her mom that
Oh,
says it, is that just because you can doesn't mean you should. So again, if you have the ability to do this, we still recommend talking to your association attorney well before you do it to make sure, one, that you do it properly, that it's reasonable, and that there's not some extenuating circumstance that would maybe make it not a wise idea.
right. And I guess what I was saying also, winter or summer, it's not only just for the comfort or the safety of the occupant, but if you want to think about it selfishly, if you're in a high-rise condominium and you're shutting off, or in any kind of a building, you're shutting off power to a unit, is that going to affect water, pipes freezing and things like that? So there's just a lot of things to think about when you're looking at this. So it's definitely talk to your counsel if you're seriously considering taking this kind of action. Okay. The next question is, please clarify the following. If a quorum is required at a regular meeting to pass motions, but a quorum is not required to ratify a budget, what rules the budget ratification that's held during an annual meeting? So I guess I think to synthesize this question is, if you're having a budget meeting at the same time as your annual meeting, do you still need to have a quorum to have the ratification of the budget meeting? And the answer is no. So if, for example, you schedule your budget ratification meeting at the same time as your annual meeting and you don't have enough folks show up for the annual meeting to constitute a quorum, whatever that number is in your governing documents, you can still hold the budget ratification meeting, because remember, you don't need a quorum. And you also don't have a motion to approve the budget. It's just if enough folks, over 50%, over a majority of the community, votes to reject the budget, then the budget is not ratified. So I know that seems a little bit confusing, but if your current bylaws or governing documents say that your budget meeting requires a quorum, that's not accurate anymore, because the statute overrides that and says that a quorum is not required to have a budget meeting. So even though you're having one meeting in terms of the time and place, you have different requirements for the types of business that you're doing at that meeting, right? So again, you could have a full quorum for your annual meeting and the budget meeting doesn't affect the budget meeting anyway. And the same thing goes if you don't have a quorum for your annual meeting. So you're going to have the same outcome for the budget regardless of how many folks show up for the annual meeting. And that's a pretty common situation to have both those meetings at the same time. It just makes sense. But you don't need to worry about quorum for the budget portion of the meeting. Anything you want to add to that, Katie? I know it gets a little bit confusing.
Yeah, the only thing I'll emphasize is like Lisa said, you can ratify your budget if you don't have a quorum. It just means that if you have other agenda items like electing board members or doing something else at your annual meeting and you don't have a quorum, that stuff doesn't happen. Okay, so our next question is Pierce County and my own addition, other counties allow for combination of lots to reduce taxes. Our HOA assesses dues per lot. If an owner has combined their lots, do they pay for the new sum of one lot or do they pay for their original deeded lots? So this question is too specific and it would require seeing your governing documents and applying the law to the specific situation. You will need to look at your governing documents to see if they address this. But as an overarching comment, there is a difference between the taxable parcel from the county and the individual lots on each plat map or survey maps and plans. Generally, whatever your county parcel lot is, that's taxed for the county. Whatever your lot or lots on your survey maps and plans are, that is what matters for the association and the charging of assessments. The number of lots as shown on the original plat maps will determine the number of assessments paid by the property owners. How the county treats that land is not relevant. Most communities we work with require two assessments for two lots that are combined into a single tax parcel. Now, there may be ways to combine two lots within your association's governing documents so that you only have to pay one assessment. But again, we would need to see your documents to know what that would look like. And typically, while you may reduce your taxable value by being two lots with the county, combining two lots for association purposes does not always reduce the assessments owed because of math and how the assessments are created. So if this is a situation in your community, talk to your association attorney. Whatever you do, you have to be consistent. So if this is something you have and you have one group of people where you want to allow them to have reduced assessments because they're one county parcel, even though they're two assessment lots, but not for another group, as always, we have a problem. But again, you should talk to your legal counsel about this. But in general, whatever the county does, unless it changes the survey maps and plans, will not impact the payment of assessments. And the follow-up question to that is, what is the purpose or advantage of combining lots per the county rules? We won't know for your specific county. It's not relevant for how the association deals with the lots as platted. But it sounds like if your county allows the combination of lots to reduce taxes, that would be one of the advantages. It just, again, does not impact what is owed to the association in terms of assessments. All right, our last question submitted in advance, and I know there have been some questions coming in the chat, so get more questions ready. Our last question is, if three board members show up at an advisory committee meeting, does that somehow constitute a board meeting? I'm going to say no with a big but, big caveat. So, as a reminder, any meeting of the board for specific discussion of this, you can't like have social meetings. Any meeting of the board is a board meeting. You can't have incidental meetings. Calling it something else does not magically make it not a board meeting, meaning you can't have like a wine and cheese night and say it's not a board meeting if you're discussing association topics and you are making decisions. The reason I said but earlier is because if you have an advisory committee and they are discussing what they have been created to discuss and they are not making decisions, the fact that three board members happen to sit on the advisory committee does not magically make it a board meeting. Now, what would magically make it a board meeting is if they then started to make votes and have a discussion on what they're discussing in that advisory meeting. The term advisory is not defined in the statute, but if it's a planning meeting in advance of the next board meeting or something like that, and you have a quorum, then you have a board meeting and you need to comply with the open meeting requirement. But the advisory only committees that the statute talks about, those do not necessarily have an open meeting requirement. Now, they can be open. And so we have some clients who are just making everything open because it's easier than trying to figure out what is or isn't. But all of whether or not a meeting needs to be open depends on the discussion. So that's basically it. The only other thing I'd add is this question said if there are 3 board members and if they show up, does that constitute a board meeting? And it can get sticky. Now, if it's 3 board members and 1 non-board member who show up, it's still an advisory committee unless the board members have exclusive decision-making authority. But then it's not an advisory committee. So basically, look at what you're talking about and who's there to talk about it. If you're worried, just have an open meeting. 90% of the time people don't show up. And I know people are like, oh, but we have that one person. As long as you're not making any board decisions and this committee doesn't have the authority to make decisions delegated by the board, then it is probably not going to just automatically be a board meeting because 3 board members are there. Anything to add, Lisa?
Yeah, I was going to say, I think you said this, but just to reiterate, we're talking about 3 board members here, but look at what your quorum requirements are also, because that might not be a quorum for your board, but I think we're going on the assumption that that would be here. I think we also have talked about before that sometimes boards like to do this to kind of get around having folks there. And if that's what you're doing, then that's definitely a board meeting. You definitely should be having folks come and give them their 3 minutes to talk and then just sit quietly and keep them muted while you have your conversations. If there's a question, I guess, in your mind, then I would, as Katie said, I would treat it as a board meeting.
All right. Well, our first question in the chat is, we have no CAI attorneys on the Olympic Peninsula. Because that seems important, should we have a local attorney as well? So we can't tell you what attorneys you should or should not have. I will say our office, and I know others, we have clients all over the state. This area of law is highly specialized. So it may not be worth having someone who is less specialized as your attorney just because they are geographically closer. There is not a lot of variation between counties in terms of practical application of the law. And so if you want someone closer who is specialized, great. But I will say it is not necessary in most situations. And if an attorney is not able to assist you because of a locality issue, meaning specialized locality, they will tell you that. Lisa, I don't know if you have a different opinion, but
No, I agree 100%. I mean, and as we alluded to, I do mostly collections work. I appear in court relatively frequently, and 90% of our courts do Zoom appearances now. So being in person isn't necessarily a requirement. But again, this is a decision for your board to make. But if it were my board, I would want to make sure that the person knew what they were talking about, not that they were down the street. But that person down the street might be the best person for you. So, I mean, again, as we've also said in other times, I think Valerie said, your mileage may vary. So do what's right for your board. But I don't think, as Katie said, being close to you is the necessary requirement.
I will say there are plenty of attorneys who are not part of WSCAI who do work in this field. We just don't know them as much because they're not as involved, but that doesn't mean that they're any less qualified. It's just we know that people who are involved in WSCAI are at least more likely to be on the top of all the changes that are coming and whatnot.
Yeah.
The next question is board members review draft minutes of meetings and add their comments to the draft. Some members want to embellish the minutes by adding commentary or additional information that was never discussed at the meeting. They also want to include details that aren't really important to the board proceedings. What is the proper / recommended protocol for recording minutes for meetings?
It's one of my favorites.
Do you want to?
Well, I'll just say that none of that stuff is relevant. What you need to have on there is basically, if you want, who was there, the date of the meeting. Basically, you use your agenda. Was there a motion made, discussion happened? That's really all that needs to be on there. The meeting minutes are a reflection of the actions taken by the board. So all that other stuff isn't relevant to the workings of your association. When I've been the board secretary, I just literally use the agenda and just write motion by X, unanimous or whatever the decision was, and then move on. And I know people want to have an explanation. I think it's a decision of your board what you want to do, but it's not necessary. That's for sure. Putting who dissented sometimes can satisfy some of the folks because they want to make sure that if a decision is of record that they didn't vote for it, that they want to be on record. That might be appropriate or would be appropriate. But in my opinion, none of that stuff is relevant and is not required for the workings of your association. But again, if someone's going to be refused to approve minutes because a discussion, the topic isn't there, that might be something you negotiate with your board. Anything you want to add to that, Katie?
Yeah, I would say first look at your bylaws because I know the ones we draft say you follow Robert's Rules of Order. And Robert's Rules of Order does have information on meeting minutes. Board members do have a right to have their dissent recorded if they object. But as Lisa said, this is supposed to be a record of the action taken, not a transcript of what happened. And I know in the question it said additional information that was never discussed at the meeting. So the minutes are supposed to reflect action taken at the meeting. So if it's something that was not at the meeting, that is probably not appropriate to be included. I will say if it was an action taken outside of a meeting and you are re-ratifying a decision made by the board in those meeting minutes, that should be included because you're ratifying the decision made by a board. It also may be appropriate to include what the board relied on to make a decision. So an attorney opinion letter, a contract, whatever calculations or something, that can be appropriate to include, but it's not a discussion of what it is. It's just here's what the board relied on. There's a question of the owner forum input, how much detail, if any. Our position is you don't need to include any detail. Now, if there's an action item that comes from the owner forum, Sally comes up and she wants to talk about planting begonias, and the board's like, oh, that's a good idea. You can put that in the minutes that she spoke about that and the board will follow up. But that would go in like the new business or the action item section. You don't need to put how long people spoke. You can put who spoke at the owner forum. And if broad topics would be helpful for you to look back on later, then you can include that. But you can just say owner forum because
And you
there's
could,
no
yeah,
decision making that takes place there.
exactly. I was just going to add that you could even just have a paragraph that said owner forum discuss topics like the playground, the pool, and cutting the trees at the clubhouse.
Yeah.
Period. Or something like that, if you want to make sure that everyone's reflected in there.
Yeah. All right. So our last question submitted in the chat is when the CC&Rs and bylaws conflict, does a board resolution allow for clarification? Or will the documents have to be restated to match? For example, the CC&Rs state the fiscal year is from January to December, but the board can establish a different fiscal year. The bylaws state that the fiscal year is from September to August. The board would like okay. Short answer is you have a hierarchy of documents and your declaration or your CC&Rs is higher in priority than your bylaws. So if there is a conflict, your CC&Rs will prevail. So for example, in this case, if the CC&Rs say that the board can establish a different fiscal year, they can establish a different fiscal year. And if that happens to be the fiscal year that's set in the bylaws, great. Um, so that's the short answer. Ukiah does allow for the board to make amendments to the declaration only to resolve conflicts between the CC&Rs and Ukiah. Everything else requires like a vote of the owners. So if this question were when the CC&Rs and the statute conflict, then the board could amend to comply with the statute of Ukiah only once Ukiah applies. That does not apply to if there's a conflict between the statute and the bylaws yet. I know there is a push to give that same authority for the board to amend bylaws to resolve direct conflicts, especially because that's where most of the direct conflicts are right now, are between Ukiah and bylaws. Um, so that was a long roundabout answer with a bunch of other information, but basically your documents, your CC&Rs are higher than your bylaws. If there's a conflict, follow your CC&Rs. Anything to add, Lisa?
Not to that. There is one more question in there. It says,
Can a board issue a revised budget during the fiscal year?
and the answer is sure, you just have to go through the same process you would for another budget. So, and this often happens with like a special assessment. You'll have maybe a half year, you'll realize you need a new roof or whatever the thing is. And so you create a special assessment budget and hold a ratification on that. If it's just the full budget, you realize this is absolutely not the picture of what's actually happening. We need to revise this and do it again. You can absolutely do that, but you just need to make sure you're following the process outlined in 649525 to have the right notices, please, and the right information in the budget notice and budget packet that goes out to owners ahead of the meeting.
All right, we have another question, and I'm going to read it, but I reserve the right to say it is too specific as I read. I have a condo owner who would like to pay directly for repairs to a common element so the work can be completed sooner. The owner is asking whether the amount he pays could be credited against or deducted from a forthcoming special assessment that would otherwise be charged to his unit. Is this permissible under condominium law and our governing documents? And are there any risks or procedures the association should consider before agreeing to such an agreement? So the last sentence really kind of solidified it. We cannot answer this question. We would need to look at your governing documents and to know what the project is, how much it's going to cost, where you are in the process, and a bunch of other information that we cannot advise in this setting, and it would be inappropriate to do so. So
Agreed.
the next question is if a board moved operation expenses into reserves and didn't notify the owners, then later removed them, is it still a requirement to notify the owners if expenses were incurred?
So it sounds like they moved money into the reserves and then took them out. I guess I think I might need more information here to know exactly what's going on. And this sounds pretty specific. I mean, there are specific, obviously, if it's part of the budget and it was authorized in the budget, great. If it's something that is not authorized in the budget, that probably just as a general rule would require notice to the owners. But I don't know in this case exactly. I think it's too specific for me to answer.
I agree. I think this question is looking for a specific answer that we cannot provide in this setting without more information. And I don't think it's appropriate that we continue with it. So if you want to submit it into the Q&A for next week, they may have a different opinion, but I think right now it's not, I think it's too specific.
I think we're probably getting to the end here, Katie. What do you think?
I
Give
think
everybody a little chance to get out early.
Yeah, I think so too. Thank you all for joining us today. Please submit your questions to info@condolaw.net by 4 p.m. on Monday, and we will get to them. And I hope everyone enjoys the rest of their week.
Have a great week. Thank you.